one that said, man told me if anything ever happens to me, Carter did it. And in our case, we have a 911 caller saying, my panicked neighbor told me Thug is in her house.
A little different now in this situation. I mean, I just, it's just fundamentally a little different from Carter versus what we have here.
Your Honor, the analysis, I understand that the defendant would rather not have his name mentioned, but the fact that he feels...
That's not the point, Ms. Love. The point is, Pitts tells me that I have to, I mean, then Chief Justice Sears makes it very clear. Courts are to determine and take a look at 911 calls in particular about some things that may be non-testimonial and testimonial. So that's kind of what we have to kind of do in this particular circumstance. And that's why I'm kind of concerned that, and especially since it's being communicated through a third party, but it specifically names Mr. Williams in that particular regard.
And if I may, Your Honor, when the courts, every case that we look at, there is never a word-by-word analysis. The court looks at the entirety of the statement to determine if at some point it turns testimonial.
Well, you're right, and that's what Pitts tells me to do. So I have to kind of look at it from that standpoint.
And the intent of the caller is what makes the statement testimonial or not. If the caller intends...
But some portions of the statement, remember, that's what Pitts tells me to do. I have to look at whether or not some parts of that statement are testimonial.
Right.
And that's kind of that's what Pitts directs me to do.
And it's only testimonial, Your Honor, if its primary purpose is to establish evidence that could be used at a future trial, in a future prosecution.
Well, I would think that naming a potential suspect would be evidence useful in a prior trial. I know you're shaking your head over Ms. Hilton, but that's... I'm sorry, okay? That's just the facts.
Your Honor, what I was saying was
that's just the facts, okay? Just like I told Mr. Steele, evidence may not cut, it is what it is. It cuts both ways. So it's kind of like, this is what our highest court tells me I have to do. Now, you all may disagree or not like it, but that's what I gotta do.
I agree with Your Honor, absolutely. And all that I'm saying, Your Honor, is that every single case that we have regarding the confrontation clause, in every one of them, a person is named. The person is named that is alleged to have done the thing that is causing them to make the statement.
It depends. Like I said, it depends on, you have to look at, Crawford tells us in his progeny, and even in our jurisdiction in Georgia, you have to look at the primary purpose of the call. Was it testimonial nature? Was it made for the purpose of gathering criminal or fostering for use for trial or for potential criminal prosecution? There are certain exceptions to it, and the emergency situation is one. But even with the emergency situation, Pitts tells me, got to look at whether or not some of those particular statements are in fact testimonial. So even if I believe, first I got to decide whether or not it's testimonial or not. And even if I decide it is non-testimonial, it's an emergency, then some of then I have to look at, and Pitts directs me, I got to look at very carefully whether or not some of those statements are in fact maybe non-testimonial, maybe testimonial in nature. So that's what I'm required to do.
And Your Honor, we are looking at a caller who's describing and trying to get the police to respond, even when the 911 operator is asking her who was shot. In other words, she's telling her, I need you to come. I'm not sure what the apartment is. She's in building C when you're coming around through the gates. The 911 operator is trying to get information about the shooting, because she said that shot somebody, like has already shot somebody. 911 operator trying to get information about the shooting. She said, I promise you, I can't tell you all that. I ain't trying to talk to you about that. I ain't trying to give you anything for your evidence for your prosecution about no shooting. I'm telling you that the guy that shot somebody, Young Thug, is in my neighbor's house. And I'm trying to get her out the house, and she won't answer her phone. So it's not about who got shot or who he is alleged to have shot. It's about he's in her house now. This man, potentially armed, is now in her house. The reason that it is important that she names him and that she says who he is and what he does is twofold. So just with the information that the court has already heard, the court already knows background. But just for future purposes, there is an accomplice statement that we intend to have presented as evidence that I will state in my place that one accomplice ran one way and Thug ran in the opposite direction. And that opposite direction is exactly where this caller is calling from. I should have followed Thug. I should have went left. I went right, or I went to the left and he went to the right. I should have followed Thug. And then here we have this caller saying, I ain't trying to talk about this shooting over here. I'm trying to tell you that this man that just shot somebody, Thug, is in her house. And I need you to get her. I need you to come and get her out because her mom and her baby are in that house.
Okay.
And Your Honor, that's the reason those circumstances, that information, the caller's words, her purpose that she reveals. When she tells the 911 operator, I can't tell you all that. I don't know. I don't know who got shot. I don't want to talk to you about that. The only thing I want to talk to you about is the reason I'm calling, because Thug is in my neighbor's house and she's panicked. Just as if the court is going to go, if Your Honor was going to go and respond to someone, you'd want to know who it is and what it is you're walking into. You'd want to know if your neighbor came to you and said that somebody is in our neighbor's house, you'd want to know, is he armed? Who is it? That information is to help you respond to that threat that is happening right then. You would not want to walk up to a circumstance you don't even know.
Yeah, you told me that last time. I remember. So, but how is it different if if the person is directly communicating the information to me, or am I getting it through somebody else?
Your Honor, that part, it is not different for the confrontation clause analysis. That part remains the same. Its purpose remains the same. When you get into who said what, that's the hearsay within hearsay, and both of those statements fall under 24-8805 to an exception. And the court analyzed it exactly correctly when the court said that's for the jury to determine, because Mr. Steele argues you don't know that was actually true. The court analyzed it on point. The court said, well, you can argue that, and the jury can say, well, she says she don't know. I don't know, Young Thug. The jury can decide what portions, if any, of that 911 call.
But we don't have a declarant. Our declarant's unknown. Our two declarants are unknown.
And that is why, Your Honor, the whole purpose for exceptions for hearsay are to put forth things that are trustworthy. And hearsay within hearsay is not, it is absolutely admissible. And the court knows, I don't even have to say this, it is only for the purposes of the record, that these new evidence rules are rules of inclusion. So much so that the rules don't say it can be admitted if you have an exception. 24-8805 specifically says hearsay included within hearsay shall not be excluded under the hearsay rule.
Well, Ms. Love, I'll tell you. Spratling, which was decided in 2023, says if I don't make a proper analysis under Crawford, vacate and remand. So,
and Your Honor,
so I got to make sure I get it right, okay?
And Your Honor, I'm with the court. I'm absolutely with the court, and I have an equal desire, if not greater, to make certain that it is right. And I would not argue fervently for this if it were wrong.
All right, well, let me have 5 minutes, okay? I'm going to take a break. And
it's possibly 30 seconds.
Because your 30 seconds is never 30 seconds.
30 seconds, and I will sit.
You can stand there, that's fine. Go ahead.
I just need you to understand, and I'm not saying you don't understand, but the Cardiff case that was just cited, 315 Georgia, 214, Division 3, A doesn't apply, that's the 807 residual hearsay. B is what the state was talking about. And, Your Honor,
There was no objection in this case either, so.
No.
In the Carter case, no objection, so.
look what happened.
And they had to review it under plain error too.
Yes.
So, yeah.
Fox was told by Miss Mann, God forbid, Valerie Mann was killed. Fox testified. Valerie Mann, God forbid, is dead. And she told Carter. Carter testified. That is not even close. So I don't have anybody. That's my privilege.
And Your Honor, I'll give the court, if the court already has page 3 or 4 of Pitts, where the court said the caller in this instance,
Pitts, yes, ma'am.
okay, was not, they were not concerned with establishing evidentiary facts or bearing testimony. That's the part against the defendant. And the court found that the same analysis was applicable in Pitts. That the 911, that portion of the 911 caller, they were not concerned with establishing evidentiary facts. They were concerned with getting Young Thug out of their neighbor's home.
Okay, all right. Give me 5 minutes. Y'all can do the same.